Hola and warm festive greetings to everyone who's joining us today. My name is Abdul Mufi Shahid, and I'm the Engagement and Outreach Lead with the Pacific Island Students Fighting Climate Change. This is session 2 of our public webinar series hosted by PIS-FCC. On behalf of PIS-FCC and our panelists, I'm thrilled to have you join us on this very important conversation. Today's session, From Legal Principle to Action, the ICJ Advisory Opinion and the UN General Assembly Resolution is a critical conversation in our shared pursuit of climate justice. The past 6 years saw a historic global solidarity movement of people's power in campaigning for an advisory opinion from the ICJ to clarify state obligation with respect to climate change. Following the advisory opinion from the ICJ last July, a new UN General Assembly resolution led by Vanuatu and a core group of countries seeks to operationalize this legal milestone across the UN system. This webinar will explore how the resolution can strengthen implementation and accountability and help bring the court's ruling to life. We have a lineup of exceptional speakers today, and I'm personally honored to facilitate this discussion with powerful women in the climate justice space. It is also fitting that I wish everyone on this call a happy International Women's Day, honoring women who are on this call and those who are not here, who are breaking the glass ceiling in leading social justice causes. A quick look at how this webinar will go today. We will start with 10 minutes intervention from our 4 speakers, followed by a Q&A session. If you have any questions as the webinar goes on, feel free to use the Q&A feature at the bottom of your screen. Send us your questions and we will be posing them to the speakers after their interventions. Our speakers today are Ms. Lee Ann Sackett, Vanuatu's Special Envoy for Climate Justice, Her Excellency Mary Robinson, former President of Ireland and a distinguished member of the Elders. Professor Margareta Weverinck Singh, Associate Professor of Sustainability Law at the University of Amsterdam, and Ms. Nicole Pons, World's Youth for Climate Justice Representative. We look forward to an engaging and insightful discussion, and thank you to our speakers for being part of this very important conversation. Again, I would like to remind all attendees that there will be a live Q&A portion of the webinar, and we encourage you to use the Q&A feature of the webinar, the Zoom webinar, to drop in a question. To open today's session, it is my great honor to introduce our first speaker, Ms. Lee Ann Sackett. Ms. Sackett is Vanuatu's Special Envoy for Climate Justice. She was also the former Director of International Legal Affairs for Vanuatu's Climate Justice Program. She's also a member of the Permanent Court of Arbitration and Chair of Vanuatu's National Group and an academic at the University of the South Pacific. Her leadership has played a pivotal role in leading Vanuatu's historic efforts towards the ICJ Advisory Opinion campaign. Lee Ann, the floor is yours for your introductory remarks.
Thank you very much, Abdul. It's my absolute pleasure to be with you all here this morning, and such a great honor to be a panelist amongst such a distinguished group of women panelists here today on International Women's Day. I didn't actually realize until you mentioned it, so that's a real treat. So thank you everyone for being here. I have been asked to speak a little bit about why Vanuatu decided to lead the UNGA resolution now and what are the core objectives of the resolution. So I'll start off with that. I think everybody's fully aware of the consequences of climate change being alive and not so well in Vanuatu. Just last week, we had another cyclone come through, and it's very much not a future risk for us anymore. It's a present reality lived in Vanuatu in the everyday lives of all people in Vanuatu and communities. It's resulting in loss of land, loss of culture, loss of livelihoods, sea level rise. The impacts of it are significant, to say the least. And so this is the same situation in many other small island developing states as well, and other climate vulnerable states. And as we increasingly speed towards climate catastrophe, despite our best efforts under the UNFCCC and the Paris Agreement, or the climate regime, just to express it more simply, we obviously saw a need to look for other avenues as well outside of the existing mechanisms. And so these existing processes have made a lot of progress. So just give you a little bit of background before we jump into the resolution itself. So while these processes have made a lot of progress, the scale and the urgency of the crisis, they require stronger clarity on states' legal obligations. And this is essentially what drove the initiative to request the advisory opinion in the first place. And Vanuatu was backed, as I mentioned many times, possibly pushed a little bit by our inspiring youth from the Pacific Island students fighting climate change. And that led us to the International Court of Justice, where we secured an incredible advisory opinion of a unanimous advisory opinion from the ICJ, who confirmed that climate change is not just a matter of policy or politics, it's a matter of justice and international law as well. And so the key findings of the court were very supportive of the climate justice objectives that drove us seeking an advisory opinion in the first place from the court. The court confirmed that international law is not restricted to just the climate regime and the treaty obligations there, but in fact human rights law, other treaties as well, and went further to say that the obligations of states in relation to climate change are owed to the international community as a whole. And this is a very important aspect of the opinion. But even more importantly, they confirmed that the rules of state responsibility also apply to breaches of obligations, of climate obligations. And what flows on from that is the full suite of legal consequences under those rules of state responsibility. So now that we have this wonderful opinion, which was everything we expected from the court, we now need to return back to the UN General Assembly as is standard practice. Once the UNGA they requested the opinion from the court via resolution, and so it's now standard practice to bring it back to the UNGA to have that advisory opinion endorsed at the political level. And as is often seen in resolutions following advisory opinions, having the opinion operationalized as well. And so the core objectives that we've been working on in this resolution and are part of the current draft that is being negotiated by the membership of the UN at the moment are threefold. So the first one and the most important one, which is uh, not negotiable, even though it is being negotiable, but at least from Vanuatu's perspective, absolutely not negotiable, and for the large majority of states, not negotiable as well, is a full and unqualified welcome of the advisory opinion. And to get a full and unqualified welcome of the advisory opinion, we need to do a few things. So first of all, actually state that the UNGA, through the resolution, is welcoming the advisory opinion. So not simply taking note of it or acknowledging it. This would be far too weak for an advisory opinion of this magnitude. The consensus requesting resolution, the unprecedented levels of participation in the court. I mean, the case became the biggest court in the history of the ICJ that then resulted in a unanimous opinion from the court. So to accept it in any other way than a welcome would be unacceptable, I think, for Vanuatu and many other states, and the large majority of states as well. So that's the first thing that needs to be done in the opinion. But we also need to have the resolution endorsed, well, accepted or voted on, ideally by consensus. But the current political context and global context is a little bit challenging at the moment. Positions have changed a lot, and governments have changed as well since the first requesting resolution was passed by consensus. And so, if it's not possible to pass it by consensus, at the very least, we need to make sure that it's broadly supported by a large number of states. And if we think back to the requesting resolution, this was supported or co-sponsored by 132 states. So this would be a minimum that would seek out for to, I think, be classified as having this resolution broadly supported. Ideally, many more as well. We've seen other resolutions more recently pass with about 150, if not by consensus. So ideally, these are the numbers that we're looking at to pass the resolution. And this is very important to ensure that we protect the authority of the court's findings, the integrity of the ICJ and the rule of law, and more broadly, the rules-based order in which international relations functions on. And I can't think of a more important moment in time to really be strengthening this. And so we need to also ensure to have a full and unqualified welcome of the advisory opinion, that when we refer to the opinion and its legal findings and the obligations that were clarified, that there are no dilutions of the court's findings, there's no reinterpretations or minimizations of the important legal findings of the court and its unanimous character. So this is the absolute bare minimum that we need to achieve out of this opinion, out of the resolution, sorry. So we start off with that. That's the starting point. We then move into looking at ways in which the resolution can strengthen climate action. And so there are calls on states to action obligations that were clarified by the court. And all of these calls to action on these obligations are well, on alignment with states' obligations, more accurately, focus on states' conduct aligning with the court's obligations. And so the resolution addresses all of the obligations in various different ways that the opinion that the court addressed in its opinion. And then the most important part, and what is really at the heart of the initiative and Vanuatu's highest priority in the resolution and just in the initiative generally, is advancing climate action. And we're trying to do this through the operationalization of the advisory opinion's findings, particularly in relation to state responsibility and climate harm under international law, by advancing the ideas around exploring the registry and a mechanism. And this is very important architecture that can be looked at by the UN General Assembly. It's an area that is missing from the climate regime at the moment. It's something that SIDS through AOSIS have advocated for within the UNFCCC and the climate regime many times, only to be knocked back, to be told, no, no, this is not the forum for this. And so we're now presenting at the UNGA, hearing similar feedback. Well, actually, interesting, like, no, this is not the forum for it. This should go back to the UNFCCC. That's where it belongs. But other states have been explicit all along the way that state responsibility is not part of the treaty obligations under the climate regime. And I'm sure Professor Margareta can speak to this in a far more articulate way than I can. But I'm just covering it in the basic details for now. So in terms of how civil society, youth, academia, and even the media, if they'd like to be positively involved, can support the initiative and the resolution, is by, I suppose, mobilizing, of course, first of all, but energizing the climate justice aspects around the resolution. We are now at the stage where we are about to release the revised draft of the resolution to members today. The zero draft was already released about a month ago and introduced to the membership. What we've been doing since then is holding informal consultations. We had 4 informal consultations. We've had regional grouping consultations across the AOSIS, G77, Asia Pacific Group, the Gulf states, the Latin American and Caribbean states, the European Union, the Western European and others groups. So we've been having extensive consultations along the way. And then through these informal processes, in fact, about 106 states have been actively participating in it. But in the room, you can see possibly about 80 to 90% of the states are actually sitting in there listening and following what's going, which is extremely high participation for negotiations on an ICJ AO resolution, which speaks to the importance of this resolution for so many states. I think many of you have probably seen in the news the US's position on this, which we're unsure of the impact that it's had. There's a lot of states that we would normally expect to be supportive of and have expressed support for the opinion, but are perhaps not being as vocal in the room. And I'm not sure if it's because they're waiting to see how things are going to progress, or perhaps how the resolution text evolves, or because of the activity of other states and the impacts of that. So in the current draft, the one that will be, not the current, but the one that will be released today, the approach that we've taken is to really strengthen the language in the paragraphs to stick to the fidelity of the advisory opinion. And this has been asked for by the large majority of states so that we're not cherry picking, so that there's no reinterpretation or going further beyond the obligations that have been clarified by the state. So you can see this in every paragraph in the resolution. But there are areas where we're not sure where the membership stands at this point in time more broadly. So coming back to the very basic, full and unequivocal welcome and the need to have broad support to ensure that that's protected in the resolution. There are some areas that are more sensitive for states. There are some areas that are slightly more ambitious or climate justice focused. And these are the areas that are most at risk in the resolution and not getting through with that broad support. And so the approach that we've taken is actually to have, in some cases, two options, option one and option two in the text so that the full membership can have a look. And it's essentially the membership that will decide on which of these options go through. And we've taken this approach, first of all, to ensure that we demonstrate that we're listening to the states raising concerns in the resolution and they're in the zero draft text, but also trying to find a balance between states that really want to see a climate justice outcome from the resolution and other states that would like to see less advancement of that in the resolution. And so those key areas that we're seeing a little bit of sensitivity around are the similar to what we saw in the advisory opinion itself, pressure to move back to the climate regime again and really focus on the climate regime rather than on the international law that was clarified by the advisory opinion. And we're really pushing back against this because essentially this is a resolution endorsing an advisory opinion from the ICJ. It's not it's not a resolution endorsing the climate regime, although it is at the same time. It's just not exclusively focusing on the climate regime. So these arguments that are coming out from some states are very unhelpful and really take us away from what the core of the resolution is really about and its core purpose is. The other areas that are sensitive and always have been, but are also included in the draft at the moment is recognition of the historical and ongoing patterns contributing to inequities and the most vulnerable groups that experience those equities. So recognition of that in the draft has been raised as an area of concern for some states, but many states are also very much strongly wanting to ensure that it's included in there. Fossil fuel phase out is obviously a very, very sensitive area for many states. It's included in there. It was included in the zero draft, but based on a lot of pressure from some states, it's now been, the language has been adjusted to a transition away from fossil fuels, which captures the language that's already been agreed to by consensus in multilateral forms through the COP28 and the UAE consensus, that GST language. So this is a major concession that's already been made from the first draft to this draft that will be released today. And any further weakening of that would be really a significant loss to the resolution. Other sensitive areas are climate finance, capacity building, and tech transfer. So climate finance in particular is a very sensitive topic. At the moment, we have two proposals in there in the draft. One's from the European Union and the other is from AOSIS. And so what we will see is test that with a broader membership beyond those two groupings, and those different approaches that have been taken to see where it falls within the broader membership. I won't take too much longer. I'm very aware that I'm taking up more time than I should. But the most important element and the most sensitive element is, of course, the register and the mechanism that Vanuatu has been talking about for some time. And in the zero draft, there were calls for the membership to agree to establishing this register. It's a register of climate harm for both economic and non-economic loss. It's a way where states, communities, peoples can have a transparent record record in documentary form of the harm that's been experienced that can be attributable to climate change. And at the moment, there is some progress towards this, but this is in other forums. But under the UNGA, this is an area where it can really be in the control of the full membership without being potentially limited by the consensus-based decision-making models that you find in the climate regime. But more importantly, it means it's not restricted to just harm experienced from breaches of obligations under the treaty obligations, but also human rights harm, human rights violations or violations of customary international law, which the climate regime is not capable of dealing with. And so this is why it's so important for it to be captured or advanced through the UNGA and in this resolution. Unfortunately, there's been a lot of pushback on this idea, as well as with the idea of an accompanying mechanism for climate reparations. And so in a really significant compromise and concession from Vanuatu's side, the new direction that we're taking now is to propose that the membership has the opportunity to explore this in consultation through a Secretary General's report. So the idea now is not to establish anything in this mechanism, I mean, anything in the resolution, but request the Secretary General in consultation with member states to explore these gaps that exist under the climate regime in relation to international law as determined by the advisory opinion, and then also identify ways in which it can complement the existing climate regime, not compete with it, not override it, but work together with it. And so those are the areas where if civil society wish to influence and align with these objectives, with these that are being pursued by Vanuatu, this is where it would add the most value. I'll stop there. And I apologize very much for taking more time than I'm allowed, but I hope that this has been a very comprehensive overview of where this is going. Thank you.
Thank you, Leanne. But no, there was some very good information on the background of the ICJ advisory opinion and the process that has happened in the last month in New York, led by Vanuatu and the core group and partners. We'll go to our next speaker, and a reminder to all our participants, please feel free to use the Q&A feature in the webinar to pose your questions to our speakers. As soon as our speakers finish with their interventions, we will pose your questions to them. Our next speaker is Her Excellency Mary Robinson, former President of Ireland and a distinguished member of the Elders. A lifelong champion for human rights and climate justice, President Robinson brings unparalleled moral authority and political insight to this moment. She joins us to reflect on a critical question. What does the ICJ advisory opinion change politically, and why is this a moment of courage for the international community? As governments prepare to act, she'll also speak to how this legal clarity can be translated into meaningful, practical steps through the UNGA General Resolution, ensuring it becomes a catalyst for real accountability. Your Excellency, we're honored to have you join us. Thank you for your time and to this important conversation. Over to you.
Thank you very much, Abdul. I hope you can hear me. Okay. I'm very pleased to participate and very grateful to Anna Lee for bringing us totally up to date with the new draft resolution, which will be the recast resolution draft, which will be issued today. That's extremely helpful. But I want to begin by saying what a privilege it is to join the Pacific Island students and the world youth for climate justice, because this didn't begin in the corridors of power, as we know. It began with students, and I always like to emphasize that because I want to encourage young people around the world. You can make a difference. See what the Vanuatu students did and the world justice youth did. I mean, believe now in your power in the future. You know, what happened was the young Pacific voices asked a simple but profound question. What does international law require of states when their actions are driving a crisis that threatens the very survival of others? A very important question. And I commend the continued leadership of Vanuatu itself in helping the world move forward through working for tabling, getting the resolution passed unanimously, etc. Taking the ICJ advisory opinion back to the UN General Assembly is the next important step in the process. And as Anna-Lee said, it is totally in accordance with procedure. There's nothing unusual about it. And the fact that the resolution was unanimously supported means there should be a real wellspring of support by states for this resolution. So, we have to get away from the current situation of thinking of climate as somehow nice to have if you're in a good position, but if there's any problem, it goes down the agenda. For too long, climate action has been seen as a matter of political will, of nationally determined contributions, voluntary ambition, and negotiated compromise. The difference the advisory opinion has made is that climate action is now presented as a legal obligation. The advisory opinion reaffirms that states must exercise stringent due diligence, including by regulating corporations within their jurisdiction. It confirms that general principles of state responsibility apply, including the obligation to cease wrongful conduct and to provide reparation where appropriate. Politically, this changes the terrain. It empowers vulnerable states. It strengthens the hand of domestic courts. It gives civil society and young people a clearer language of rights and responsibilities. When the law becomes clear, frankly, excuses become harder to sustain. Today, the global community has an opportunity to come together to translate the ICJ's guidance into concrete action. It's an invitation for countries to show they uphold the rule of law at a time when it is under pressure globally, I'm sorry to say, including in one particular important country. Standing with Vanuatu means standing with the international rule of law, with science, and frankly, with solidarity. Backing this resolution is a reaffirmation that international law matters, that multilateralism matters, that justice matters. I hope European community countries, European Union countries, including my own country, Ireland, will come very strongly out in favor of this resolution. I'd encourage all countries to engage constructively and actively with the informal sessions currently underway at the UN General Assembly. And I was pleased to see Anna-Lee say that although there were 100 and something participating, there were many others listening. That's important. But having listened, remember what your values are. Work with Vanuatu and the core group of states to craft as ambitious a text as we can, given the climate that we're in. And I think Anna-Lee has outlined that very well. But you have two options in a number of places. Take the strong, courageous option, please. Do what you should do for the sake of the current, but in particular, future generations. Know that it's on your watch that we have to make these decisions. It's really important that the resolution passes and is welcomed with a strong majority. Member states unanimously requested the court's opinion, so a resounding endorsement is the logical next step. The opinion is not an attempt to rewrite international law. It's a reaffirmation of it. The resolution, but frankly, we must remember that resolution or no resolution, the advisory opinion of the ICJ stands as the law, as clarifying the law, as applying, so the domestic courts in litigation will also apply it. Let me end by saying that the climate crisis is the defining human rights challenge of our time. It's also a test of whether the international community believes in the rule of law. The advisory opinion has illuminated the path. The General Assembly now has the opportunity and, frankly, the responsibility to walk that path, to uphold the rule of law, to endorse this advisory opinion, to accept what the court has said. Thank you.
Thank you so much, Your Excellency, for your very inspiring remarks and for truly grounding us in the importance of this moment. And your last sentence was really what's important, that the UN General Assembly has the responsibility to follow through with what they started by the unanimous decision, a unanimous request from the ICJ, who then passed a unanimous advisory opinion, clarifying state obligation, and now welcoming it in the strongest terms at the UNGA. Now, it is my pleasure to invite our next speaker, Professor Margareta Weverinck Singh, who is the Associate Professor of Sustainability Law at the University of Amsterdam, and she was one of the leading voices in international climate law and has been at the forefront of efforts to clarify legal responsibilities for climate harm and was lead counsel for Vanuatu at the ICJ proceedings. She'll speak to a crucial question, which is, what are the most important legal clarifications in the ICJ Advisory Opinion, and how can the UN General Assembly resolution help embed those principles across the UN system? Professor, over to you.
Thank you very much, Abdul and Nicole. Thanks to all of you at World Youth for Climate Justice for bringing us together and keeping the conversation about the advisory opinion alive, also at this stage where it still matters so much and the work needs your continued advocacy to ensure that the international legal system delivers on climate justice. In the few minutes speaking time that I have, I'd like to take us all just a few steps back and reflect on the negotiation of Resolution 77-276 that requested the advisory opinion from the court, just to kind of freshen up our memory and kind of put a spotlight on what was at stake there, what was the battle that was fought, what was achieved, then what happened at the court, and where are we now, and how do we ensure that the vision that underlied the resolution and then the opinion now is translated into further action through this new resolution. So those of you who have followed the process very closely will know that the resolution that requested the opinion from the court posed two questions. Right? So what are the obligations of states to protect the global climate system for present and future generations, essentially? And then what are the legal consequences for states that have caused significant harm to the climate system and other parts of the environment, and then vis-a-vis states that are injured, essentially, and then peoples and individuals of the present and future generations. And this second question, I think we can characterize as the climate justice question. And telling is that the most heavily negotiated part of the entire resolution, where these two words have caused. And so why did these two words matter so much? Because it enables us to reflect, and it invited the court to reflect through the prism of international law on how this problem of climate change was caused in the first place. So it's about accountability, and then also who are harmed by this problem already. Those are states, but also rights holders on the international human rights law, peoples and individuals, and then of course very importantly of present and future generations. So this temporal framing is important because it requires reckoning with the past, and of course by implication also changing how we do things at present, because accountability in this way also accumulates. So and insofar as it is unlawful, it must cease when it is indeed characterized as a violation of human rights, for example. And then of course it's about the future, not only about preventing human harm, preventing harm to the climate system and human rights violations, but also repairing harm that has been done in a way that ultimately must be transformative, because when we look at the root causes of climate change, of course, it's systemic, and so addressing climate change requires not only reducing greenhouse gas emissions, but it requires changes to the entire way things are done in the international economic order also, but also at the societal level, political level, cultural level, etc. And the court, as we know, duly answered both questions. And so the opinion sets out the obligations that are applicable, but also legal consequences of breaches. And that brings us to where we are now, at the point where the UN General Assembly needs to welcome the opinion and then translate it into action. Now, just a very brief reflection on the geopolitical landscape. President Robinson and Special Envoy Lian already touched on it. But very broadly speaking, of course, this is really painting with a broad brush, but if we allow ourselves to do that, we can say that during the first phase of the negotiating the resolution 77-276, and even the phase, the legal phase, so the legal proceedings, there were, again, very broadly speaking, two groups. So the climate justice champions, Vanuatu, and the group of support that surrounded Vanuatu, of supporters. And then there was another group that was slightly skeptical or not necessarily keen about the idea of seeing this request go to the court, but we're seeking minimalistic kind of answers from the courts. But broadly speaking, we're ultimately ended up voting in favor of, no, not voting, but joining the consensus on the resolution, participated in the proceedings, etc. And here the opponents, essentially, this group of opponents, were still constructive in those senses. And then the argument that was raised during the negotiations and before the court was mainly about the Paris Agreement, UNFCCC and the Paris Agreement. So their kind of mantra was almost, it's all dealt with in the climate negotiations, and we don't need the court to intervene, etc. That was translated into technical legal arguments, lex specialis, etc., etc. Now we have a third group, and those are the real, I would say, real opponents who very aggressively argue against UNGA involvement, seeking withdrawal of the resolution, or a resolution that essentially would undermine the opinion, reframe it, and is also actively lobbying to try to influence what states in those other groups are trying to do. And states who, when they would act in accordance with their own interests or what their own people want, would, for example, be wholeheartedly supportive, as they had been in previous stages, and may now feel under pressure, and very real pressure, to take different positions. And I won't go into detail as to what is exactly happening. That's not that's, of course, that's sensitive, and it is within the diplomatic sphere, but it matters in terms of the outcome that may result from the negotiations. But thankfully, there's still there's a strong sense that it is important, especially at this time, to protect the international legal order. And we see, in a world that is now characterized by an increasing violence, instability, war even, and disrespect for international law, that thankfully there is also growing realization, at least in some groups, that it is more important than ever to actually ensure that the international legal order lives up to its own promises, so to say. And so, in that sense, what is at stake here is not just follow up on this opinion, etc., but it is also a credibility test, almost, or a test of strength of whether the international legal system, to what extent it still functions. And so it's unlikely that this resolution will be a consensus resolution for that reason. But the UN General Assembly has rules on voting for good reasons. And so if the General Assembly with a good majority adopts a strong resolution, that would still be, I think, a sign that provides reason to be hopeful about the system. And then just final word on what is at stake, kind of at a deeper level. So it's the international legal order. It is, of course, the international response to the climate problem. We know that the climate system established under the climate treaties, the UNFCCC, the Paris Agreement, doesn't deliver the scale and type of action that is needed, and it's particularly so when it comes to climate justice. There is a kind of sub-regime that addresses loss and damage, but it is very weak. It has not really delivered anything concrete for victims. And so those who argue that everything can and must be done in the climate regime would have a point if you'd see them actually wanting the climate regime to be strengthened and pushing for more stringent targets, of course, adopting stringent targets in their own NDCs, but also pushing for stronger infrastructure on finance, on technology transfer, but particularly on loss and damage. And so as a matter of principle, there's nothing against doing it that way, right? Climate justice advocates are not necessarily set on building something outside of the climate regime. It's just that it hasn't happened, and those who argue that it's there where it should happen also are those that within that regime itself actually argue against progress within that regime. And then also we see that there is a tendency then to argue that yes, the climate regime should do this, but within existing mandates, within existing budgets, etc. So it's unlikely to then ever make a difference. That's unfortunate, because ultimately, if these mechanisms function well, they could do what the whole world actually really needs, and that is building this future that is grounded in these very important international obligations that are universally applicable. Also protecting states, including states that are major polluters, as they take measures to transition away from fossil fuels, for example, against claims from private investors or other kind of big stakes in the fossil fuel economy, protecting them against, for example, compensation claims, because when it is clear that states are legally obliged on the international law to do all of these things, then also it follows that other private interests need to make way for that societal need, and that also has important economic implications. So I'll leave it here, and I very much look forward to hearing who is in the room, because we can't see that, and I'm curious to hear your questions.
Thank you, Professor, and some very important points that you have raised, especially in terms of it was a unanimous ask, again, something that's been reiterated with the past, because also, and it should have unanimous vote at the UN General Assembly. That is the wish. That's on our wish list, and let's see how this goes. So, Request to all of our participants, remember that you have the option to ask questions in the Q&A feature, and we'll have Nicole speak after this, and right after that, I get to pose your questions to the speakers to respond. So keep using those Q&A feature, and we'll go to Nicole, who I've had the pleasure to also meet, and she has been someone who has been part of this campaign for a very long time. She's one of the younger elders of this advisory opinion movement. So I'm delighted to introduce our final speaker, who is Nicole Pons from the World's Youth for Climate Justice and represents the powerful voices of youth and civil society who have been at the forefront of the campaign of the advisory opinion from the very beginning. And she'll speak to a vital question, which is from a civil society perspective, why does this UN General Assembly resolution matter? And how can civil society and everyone attending support it? As we look ahead, Nicole, we'll share some how this moment is not just about governments, it's also about all of us, because turning legal clarity into action requires public pressure, solidarity, and a shared commitment to justice. Nicole, honored to have you to close the session. It's only fitting that young people started the movement, young people have a space in it. So over to you.
Thank you very much, Abdul. I hope you can hear me well. Thank you very much, and thank you for everyone for joining us today. Thank you, Abdul, Vishal, Sahil, and the PFCC team for organizing such a timely event. And of course, to the powerhouse women on this panel who have inspired and uplifted not only me, but so many of us, and who continue to lead the strategies and conversations surrounding the ICJ AO and now the UNJ resolution. So I think it's quite clear that our challenge today is different in a way, and in many ways perhaps even more crucial, because after almost 7 years of a grueling global campaign, we now have the ICJ Advisory Opinion on Climate Change, which has clarified the obligations of states under international law. Now, this marks a new legal narrative, but one that draws from a deeply collaborative and intergenerational process, championed by Pacific youth and communities and supported by the mobilization of global majority communities around the world. So this story did not begin in The Hague or New York, nor will it end there, as it began with a strategic effort by youth advocates, vulnerable states, and the broader ICJAO movement to mobilize international law as a pathway to climate justice. It will continue to be energized and propelled by such communities. And the ICJ Advisory Opinion was a watershed moment, and we have already begun to see how it is being used to shape and influence climate action. And yet to this day, even in the lead up to the ICJ proceedings and now the UNJ resolution, the same question continues to arise. Why does this matter? And what does it mean for frontline communities? How does this address the harm faced by families forced to relocate every time a typhoon strikes, or the injustice experienced by those homes that are submerged by floods that could have been prevented or mitigated? So to highlight what Vishal powerfully said in the first session, legal clarity alone does not protect a single village from rising seas. So these are fair and necessary questions. Now, a little over 6 months after the advisory opinion, the challenge before us, I think, is no longer really interpretation, but implementation, to ensure that the ICJ-AO is not relegated to a legal text, but influences real-world decisions, policies, and actions. So the opinion has already woven together human rights law, environmental law, state responsibilities, and duties of international cooperation into a clear and cohesive legal framework. So the task now is to translate this framework into real decisions, institutions, and outcomes. And I think this is precisely why this resolution matters, because it helps determine what happens next. How will the international community respond to the court's clarification of legal obligations? So as my question for this session, particularly on a civil society's perspective, the key question in this moment is really, now that the world's highest court has spoken, what will states do next? So the UNGA can now help translate the court's legal findings into political momentum, institutional follow-up, and pathways for implementation. So the UNGA resolution can really play several roles. First is that it anchors the advisory opinion within the UN system and signals that the international community recognizes the legal guidance provided by the court and considers it relevant to ongoing climate governance and not merely symbolic. So it helps integrate the ICJ opinion into existing climate processes, including UNFCCC negotiations, national climate policies, international financial discussions, and human rights mechanisms. Second, it also provides political legitimacy for implementation in what Leanne mentioned earlier on about operationalization. A strong resolution helps states, especially vulnerable states, and civil society use the opinion in domestic and regional policymaking and leverage it in the work that they're already doing at the front lines. And third is that the resolution really matters because it creates an opportunity for those most affected by the climate crisis to help shape the path forward. As what was mentioned earlier on, this process is not only about diplomacy between states, but really about justice and climate justice. It's also about whether the experiences of frontline communities are reflected in global action. So in other words, the resolution helps move the ICJ opinion from legal clarification to practical impact. So what are some of the practical steps for supporting this process? To reiterate what has been outlined in the first session, first, what we really need to do is also engage as a civil society to engage directly with governments. So everyone here today can ask, probably, has my government co-sponsored the resolution? Will it support a strong final text? And what position is it taking in consultations? So similar to some of the strategies we employed during the first UNGA resolution way back in 2023, we can also write letters to our governments, request meetings and issue public statements, brief diplomats, and work with national and regional allies to build momentum before the vote. So there are resources available, including the advocacy pack that I hope reached everyone in this session already. It has template letters and social media materials that can support these efforts. And there's also a broad mobilization call next week to provide a space for everyone to connect and engage in this work. And we warmly invite everyone to join. So engagement also means translating complex legal findings into accessible policy language, because we're still working to understand, like many governments are working to understand the implications of the advisory opinion. And I think our role is also not only to advocate, but if available, provide resources and constructive pathways that enable states to support the resolution. And secondly, to mobilize, to organize ambition. So a resolution of this nature should not be merely symbolic and should reflect the full significance of the court's findings and signal that the international community takes seriously the legal obligations clarified by the opinion. So this means mobilizing civil society, youth networks, academic institutions, and frontline communities to help generate that political momentum necessary for ambitious outcomes. And finally, to remain engaged after adoption to ensure meaningful follow-up. And the adoption of the resolution is not the end of the process. It's really the beginning of that next phase. And hopefully for the opinion to derive influence not only from the court's reasoning, but also from how states, institutions, and communities use them in practice. So to end, I think we're really now at the moment of opportunity. The ICJ has clarified the law, and now the international community has an opportunity to respond, turning that legal recognition to collective action. So it's an opportunity to demonstrate that the international community is prepared to take seriously the responsibilities it owes to each other, to vulnerable communities, and to future generations. So I'll end with that. Thank you.
Thank you so much, Nicole, for clarifying what civil society or how civil society can be engaged in this process in getting the UN General Assembly resolution past the point that we need it to. And with that, I'd like to extend a heartfelt thank you to all of our panelists for your opening statements, sort of setting the stage, and then going into the Q&A section of this. I know that there is a set of questions that are in the chat, and I've been sent those questions. And I will ask it as it has been asked in the chat. So the speakers are free. I will, of course, mention who has been asked this question, but if the speakers want to add on to the response, feel free to put your hands up using the option, or unmute yourself as soon as the last speaker has finished to add on. So the first question is to Lee Ann, which is, will the resolution's draft be made available to the media? And what does the timeline for the vote look like?
Thank you very much for that question. I would need to consult the core group on whether or not we release the current draft, as it is still being negotiated within the membership. That's something that the core group would need to make a decision on and all agree on. So please allow me to get back to you on that one. In terms of the timelines, I can be far more open about that. The next round of informals after the text is released today, so the negotiations will start on Friday, where we'll allow states to make general statements on the revised draft, and then continue on into Monday and Tuesday on the 16th and 17th of March for further negotiations on the actual text. And then after that, what will happen is the text will come back to all of the input received from states. I mean, hopefully we'll end up in a situation where all the states just support the resolution in the next round of informals and it's a closed case. We can put it up for adoption immediately. Unfortunately, we don't anticipate that being the case. And so we'll receive all of the input, incorporate it into the revised text, so that what will be the final version of the text. And then it will be up for co-sponsorship around the end of March. Or a little bit afterwards. The timelines keep getting pushed out because it's difficult sometimes to determine how long the informals will take the negotiations will take to get through the entire text, as well as how much input is received from states. We were surprised to receive so much input last time, and it took a little bit longer to process it all than what we anticipated. But we are now aiming for a new adoption date, so it's not set in stone, but this is the new goal date of the 22nd of April to adopt the resolution, which will be Earth Day. Thank you.
Thank you, Leah. And that's very fitting. Does anybody want to add on to that, or I could go to the next question? I'll go to the next question for Professor Margareta, which is, can you briefly explain a comparable example of an ICJ ruling being operationalized?
One example is the ICJ's ruling on the wall in the occupied Palestinian territory, which also, I'm saying also very optimistically, it led to the establishment of a register for damages, and that is still operational. It doesn't create a mechanism for reparations or compensation, but at least there is a possibility for victims of the unlawful conduct identified in the whole opinion to record their claims, and then hopefully at one point that will result in justice. And there are other examples of as well. Of course, the Chagos opinion is a very good example, where one of the most significant things that the UN General Assembly did after the court clarified that the presence of the UK in Chagos was unlawful, to set a deadline of 6 months, which wasn't met, 6 months for withdrawal. But it did lead to negotiations with the Mauritius government over the use of that territory, and ultimately and several other changes as well. And because of time, I won't go into detail, but it's an example that shows what decisive and very concrete action by the UNGA following an advisory opinion can accomplish.
Thank you, Margaret. And as usual, if any of the speakers want to add to the response, please feel free to unmute. I'll go to Her Excellency Mary Robinson. There's a question which says, there's a growing concern that multilateralism and the rule of law is in decline. In this current climate, how important is this UNGA resolution? Yes, that's fine. Yeah. Oops.
Yeah. Okay. Great trouble. Hello. Can you hear me?
Can
you hear
yes.
me?
Yes.
Okay. True that this is a difficult time for rule of law, made worse by the flagrant breach of law. For example, the war against Iran is in breach of the UN Charter. It's not justified. So another very blatant breach of rule of law. So it's all the more important that governments, mainstream coalitions of governments that understand the importance of rule of law, actually use this opportunity to affirm that they are in support of rule of law and in support of the strongest expression of it in endorsing and welcoming the opinion of the International Court of Justice. People will be watching this. They know that the United States has tried to bully. Can people resist a bully? I hope so.
I'm sorry, I laughed at that. Does anybody else want to add on to that? No, okay, I'll go to the next question, which is for Nicole. And it's a very simple question, but a very heavy question, Nicole, which is, what message would Nicole send to youths worldwide? Very general questions also.
Yeah, very heavy one. But I think so for young people all over the world, I think just recognize the influence and also the power. Can you hear me? Okay. That I guess every one of us have, and also I think this was something that a friend of mine shared that really stayed with me, because she said maybe when you say young people, we're lumped into the whole description of youth, but also there are young people who are experts on their own rights, young practitioners, young experts, and really just to ensure that we leverage our capacities and skills, and to have to believe that we're able to influence. This is a clear illustration of that, like Abdul, the whole ICJ advisory opinion process, that it is possible to bridge that gap between mobilization and then the legal consequences and the accountability part, and young people have that power to do so.
Thank you, Nicole. The next question we have is for Professor Margareta, which is the difficulties with getting progress in the UN General Assembly resolution seems like a continuation of stalling multilateralism. Are we witnessing judicial interpretations of climate obligations outpacing what states are willing to negotiate multilaterally? And what are the consequences? There's a second part to this question, which is, are there risks that over-reliance on litigation could further fragment global climate governance?
Okay, the first question, it's a little bit hard to answer before we have seen what comes out of the process, right? So hopefully the resolution itself, once adopted, will demonstrate that the UNGA is still playing its role and duly acting upon the clarification of international law that it itself requested. I also do think, even though overall the advisory opinion is hugely significant, and it's often said to be a strong opinion, still it's not an opinion that is radical in any sense. It clarifies existing obligations in a very rigorous and solid, legally robust way, also building on UN practice, the practice of the UN Human Rights Council, treaty bodies, special rapporteurs, as well as mostly implicitly on the practice of domestic courts all around the world that already have made findings that resemble what the court did in responding to the questions that were posed to it. So to clarify that international human rights law applies and obliges states to protect people against climate harm, etc. That reflects now a very solid body of jurisprudence from all regions, and likewise also to dismiss certain counter arguments that were made, the drop in the ocean defense. So we cannot have obligations because, or the obligations are minimal because what our emissions are just a drop in the ocean. Interestingly, an argument that is advanced by the biggest polluters. Such arguments have already been rejected by domestic courts now for like 2 decades. And so in that sense, really what the court did shouldn't be characterized as anything that was wild or radical, let alone overstepping. And of course, these kinds of questions are also built in the proceedings themselves, right? Before the court renders an opinion, it first considers whether whether it's a legal question, and whether there's a reason to decline to give the opinion, etc. And if you read the opinion, the court duly considers those questions and then arrives at the conclusion that it is proper for it to deliver the opinion, falls within the mandate, etc., etc. It would be unreasonable to say that the ICJ has done anything more than it was asked to do, or than it should have done. And let's hope that the UNGA acts in recognition of that. And then generally, of course, we hear this critique often when it comes to climate litigations. Courts overstepping, politics should deal with these problems. Is all true, at least the latter part of it, that politics should address these problems. Litigation is always second best option, but when politics doesn't do what needs to happen, then I think we should be grateful that there is a legal system that upholds certain very basic, often rights and obligations that then can discipline politics a little bit, so that things don't go out of hand even further. But ultimately, of course, the problem must be political, and that's also why what happens now in the UN General Assembly is so important, because that is like marriage of politics and the judicial intervention. So again, and let's all also do what is within our power to ensure that that these processes deliver.
Thank you, Professor. And for Leanne, I've got 2 sets of questions. One is a request, if you could repeat this portion from your earlier intervention, which is, if the questioner understood correctly, where does it make sense to push more or less gently in terms of, is it the register or is it the finance provision? and if you're able to repeat this. And we brought in another question that you could answer maybe alongside, which is Vanuatu thinking of following up with the UN General Assembly special session or UN guest, perhaps in 2027? And how can you maintain the focus of the UNG on the human rights obligation arising in the climate crisis? So where should we apply pressure? Is it registry, finance, or elsewhere? Should it be more gentle, etc.? And is there consideration for UN guests as part of following up with the campaign? And what would human rights obligation look like in terms of the climate crisis?
Thank you very much for those questions. Just quickly, before I go into answering those questions, if it's all right, I'd like to add on to the question that Margareta had, because the question of fragmentation of international law through subsequent litigation is exactly what we're trying to avoid through the register and the mechanism. I mean, this is the idea of the concept, the idea of the register, the mechanism was trying to preempt any kind of litigation coming out by creating an approach that strengthened multilateralism and cooperation through the UN member states. And we've lost that in the current draft already. There's been too much pushback on that. States have said they don't want that, right? And this was even alluded to in the separate declaration of Judge Nolte from Germany, who said, where the value and the impact of the advisory opinion will be seen is through strengthened multilateral approaches and, if necessary, complemented by litigation. But if it's seen to be a tool that just spurs on litigation alone, then it does create that risk. And so we've responded to that, we've thought about that and taken it on very carefully, and in good faith proposed this multilateral approach, but are still receiving pushback on it. And so I just wanted to highlight that point. And also just jumping a couple of steps back again to another question that Margareta answered in terms of operationalization. And I'm glad, Nicole, you also had a little bit of trouble pronouncing that, because I'm constantly making mistakes in pronouncing operationalization. But in terms of operationalization and the registers that were referred to that have been established through previous resolutions on advisory opinions, there's often a lot of talk around compensation. And whilst this has been the focus of the discourse around this and really amplified, the idea behind the register being able to document both economic and non-economic harm and the legal consequences that can address that are far broader than simply compensation. So there's, potential, for example, cessation. Many of these legal consequences can already be met through the existing primary obligations under the climate regime. So, for example, if we talk about the legal consequence of cessation, fossil fuel phase out, fossil fuel transition away from fossil fuel is exactly what that requires. We talk about restitution as a legal consequence. Ecosystem restoration is another example of how that can be fulfilled. Satisfaction is another legal consequence outside of compensation. And, acknowledgement of the harms or acknowledging that there is responsibility for the harms that are occurring is another way that this can be met. And so I really encourage, especially for those of you that are advocating here with states and would like to, and this leads as a nice segue into where does it make most sense to push, is to share this message with states to be able to explain it, because Vanuatu is a small mission. We're trying to provide outreach, but there's 189 states in the UN and we can't reach everybody. But I know the size of civil society, and with all of your passion, you probably could. And so that's a really important message to share. For states that are meeting their obligations, there shouldn't be anything to fear in this. And so in terms of what other areas we should be pushing with, it really depends on the state and what their priorities are. Whether it's a state, for example, Global South states, reparative justice is a big issue. Climate justice should be an area that most global states can that will resonate with them. And so thinking about the state's positions in previous climate negotiations, as well as what their current priorities are, their other activities within the United Nations and how that may link to them is do the background research first and then figure out where the best ways to approach support are, because not every element in the resolution is going to appeal to every state, but those that are of most importance may enable those states to support other elements that aren't as high priorities for the sake of having that priority in the draft, if that makes sense, or in the resolution. And in terms of follow-up, so also in the draft resolution is a call for the Secretary General to report annually on the implementation of the resolution, and also for follow-up for it to be an annual agenda item so that the resolution comes back every year, basically. I'm not sure if I answered the second question properly, so if not, please let me know and I can try and clarify better. Thank you.
Thank you, Leanne. We have got a few more questions, but we do not have the time. We're already 4 minutes over the time. And so I feel that this might be a good point to bring this to a close. And with the questions that we have, we'll find a way to maybe provide some response to whoever has posed them, or the webinar, of course, will be also online for colleagues to have a listen to in a few days' time. So I want to thank all of our speakers for taking out the time and having this conversation with us. Also to everybody who joined in to this call to listen in, pose your questions. Those were very important discussions for us to have the global solidarity movement in clarifying certain things within the campaign itself. And a few key takeaways, of course, is that the dates that Leanne has mentioned, there has been a shift because of the process itself. And very happy to hear that states have been engaging to an extent where submissions were a bit more than maybe expected. That means that states do want something. There's hope. And let's see where this goes in terms of voting by the time it rolls around in April. With that, wrapping up the reiteration to call to action to continue engagement and outreach with states to support the resolution as it goes up for co-sponsorship and voting. Feel free to reach out to PISFCC if you'd like further details, or to connect on the campaign on the email that should be in your chat now. You could reach out there, ask more questions. If there was a question you had but was not answered, feel free to send it there. We'll try to provide you with some responses from the speakers who are on the call. With that, thank you everyone for joining us on this call. Thank you to the speakers. Thank you to everybody who joined, and see you next time. Keep the solidarity. We still have a long way to go in operationalizing. See, I also make mistake. The ICJ Advisory Opinion. Bula Vinaka, goodbye, Mode. And that's it, guys.